Section 438 CrPC contains provisions relating to bail to a person who is apprehending arrest. This section may be invoked by a person who has reason to believe that he may be arrested on accusation of having committed a non-bailable offence. If he has such reason to believe, he may file an application either to the High Court or to the Court of Session, and through this application he will seek a direction that in the event of his arrest he shall be released on bail. This direction is what is known as anticipatory bail. When such an application is filed before the court will take into consideration the following four factors: nature and gravity of the accusation, antecedents of the applicant, including whether he had previously undergone imprisonment on conviction for a cognizable offence, possibility of the applicant to flee from justice, whether the accusation has been made with the object of injuring or humiliating the applicant by having him arrested. Taking into consideration all these factors, the High Court or the Court of Session to which the application has been filed shall take a decision. The court shall either reject the application or the court may issue interim order for grant of anticipatory bail. At this stage, the court has not heard the other party. The court has not heard the public prosecutor. Only this application of the person apprehending arrest is there before the court. On that basis, and after considering these four factors as we discussed earlier, the court will arrive at its decision. The order which is now passed by the court at this stage is known as an interim order only. It is not the final order. Once this interim order is passed, the effect is that this person shall not be arrested till his application is finally decided by the court. But till the time the court has not passed any interim order, it shall be open to the police officer to arrest the applicant without warrant on the basis of the accusation. The police officer can also arrest such a person if the court has rejected his application for grant of anticipatory bail. But as I said, if an interim order has been passed by the court, then he will not be arrested till his application is finally decided. After the court has granted this interim order, it shall send a notice to the public prosecutor and also to the superintendent of police. The purpose of this notice is to give the public prosecutor a reasonable opportunity of being heard at the time when the application is finally heard by the court. At the initial stage, the public prosecutor was not heard. The first decision by the court was taken on the basis of the application. If on the basis of the application the court has granted an interim order, then a final hearing will take place in the presence of the public prosecutor. At the time of this final hearing, the presence of the applicant seeking anticipatory bail shall be obligatory. If the court considers his presence necessary in the interest of justice on an application made by the public prosecutor. If there is no such application by the public prosecutor, presence of the applicant shall not be necessary. But if there is an application, then the court will consider this application, and if there are reasons in the application which indicate that the presence of the accused is necessary, then the court will order for his presence. When the final order is passed by the court, after the hearing as aforesaid, certain conditions may also be imposed. These are some of the conditions. The person shall make himself available for interrogation by a police officer as and when required. Another condition, the person shall not make an inducement, threat or promise directly or indirectly to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to a court or to a police officer. Here we are talking of inducement, threat or promise to a witness, and if the purpose of the inducement, threat or promise is to dissuade the witness from disclosing the facts to a court or to a police officer, it will amount to violation of this condition. There may be a condition that the person shall not leave India without previous permission of the court, and more conditions can be imposed on lines which are specified in section 437 subsection 3. Now, what is the effect of this final order passed by the court? The effect is not that such person will not be arrested. This is not a protection against arrest. An order of anticipatory bail is not a protection against arrest. Arrest shall still be made if the police officer thinks it necessary. It's not mandatory that arrest should be made, but if the police officer considers the arrest necessary, then yes, he can go ahead and make the arrest. Even if the person concerned is armed with an anticipatory bail order, arrests can be made by the police officer. The only protection this order of anticipatory bail gives is that in the event of arrest, the person concerned shall be released on bail if he is prepared to give the bail. Of course, he has to be prepared to give the bail. If he is so prepared, then he shall be released on bail as soon as he is arrested. So arrest is not averted, but detention in police custody is averted. Arrest will still be made, but he will not be detained if he is prepared to give the bail. That is the protection granted by this order of anticipatory bail. If it is not the police which is seeking the arrest, rather, if it is the magistrate who has taken cognizance of the offence and under section 204, the magistrate has decided to issue a process and that process is a warrant, then the magistrate will issue only a bailable warrant in conformity with the direction of the court. Here we are referring to the direction of anticipatory bail. So once there is a direction from the court that he shall be released on bail immediately on arrest, this direction applies not only to the police officer who seeks to arrest him, but also to the magistrate who has issued a process for calling him to the court.